They've stood at the front lines of law, leadership, and public service. From the courtroom to the classroom, Attorney Karen Jimeno brings sharp legal insight, academic excellence, and a voice that has guided national conversations. Attorney Mike Toledo, a seasoned public affairs strategist and legal mind with years in media, corporate leadership, and government reform. Together, they bring law to life with experience, integrity, and the courage to ask hard questions. Two minds shaped by the law. Two voices trusted in and out of the courtroom. This is Abogado.
Good evening and welcome to Abogado, your forum for informed discussion on the legal challenges shaping our democracy. I'm Attorney Mike Toledo.
And I'm Attorney Karen Jimeno. Tonight's issue unfolds at the intersection of law and power, where institutional roles are tested and constitutional lines are drawn. Let's look at the central question confronting us today.
Two branches of government, one constitutional standoff still unfolding.
After the Supreme Court declared the impeachment of Vice President Sara Duterte unconstitutional,
Ruling that the Senate had not acquired jurisdiction to act as an impeachment court, all eyes turned to Congress. The House of Representatives has since filed a motion for reconsideration, seeking a reversal of the ruling and affirming its constitutional role in initiating impeachment. Is this an effort to clarify constitutional boundaries or the start of a broader contest over the court's authority? Meanwhile, the Senate, acting in its legislative capacity, voted to archive the impeachment complaint. Some interpret this as deference to the Supreme Court's decision. Others see it as a missed opportunity to allow the judicial process to fully unfold. At the heart of it all, a question of power, restraint, and the balance among co-equal branches. Is Congress's assertion of institutional independence a necessary check or a point of constitutional tension?
Joining us tonight is Attorney Tranquil Salvador III, a respected legal scholar, professor, and seasoned litigator. He is a senior partner at Romulo Mabanta, Buenaventura, Sayop, and De Los Angeles law firm, and notably served as part of the defense panel in the impeachment trial of former Chief Justice Renato Corona.
He has held key roles in the Integrated Bar of the Philippines and served on various Supreme Court committees. Known for his sharp legal insight and an unwavering commitment to the rule of law, he continues to shape the minds of future lawyers as a professor of remedial law. Attorney Tranquil, welcome to Abogado.
Good evening.
Good evening.
It makes me sentimental, partner, because there was a time na lagi kami magkasama ni Attorney Tranquil with our defense team.
I
Halos
know.
araw-araw yun.
I remember that. I used to get to watch the impeachment trial of then former Chief Justice Renato Corona. And I guess it's siguro pwede natin sabihin sa ating mga tagapanood na lahat po kami dito ngayon na nakaupo dito, ay somehow meron kaming experience sa impeachment.
And all in the defense.
All in the defense, yes.
Yeah.
Sila po kay Chief Justice Corona. Ako naman po nung panahon ni dating Pangulong Erap Estrada. Kaya habang kami nagsasalita dito, ang masasabi po namin, alam namin ang sinasabi namin.
Based on experience. Okay.
Yes,
So,
partner.
Attorney Tranquil, let's go to the Supreme
Yes.
Court's decision. To start off, what is your take on the Supreme Court's interpretation of Article 11, Section 3, Paragraph 2, specifically on the timelines relating to impeachment, and those related to the 3 impeachment complaints which triggered the 1-year bar rule?
Okay. Allow me to explain it in relation to the 3 and to the 4th, so that the explanation is complete. The first one was filed in December 2, and the next one was December 4, and the next one December 19.
All
Okay?
2024.
Yes, all 2024. over a period of time, it was never referred or scheduled in the order of business, included in the order of business. Based on the mandate of the Constitution, it should be within 10 session days.
Yes.
Then it should have been referred to the Committee on Justice as mandated by the Constitution within 3 days. Having said that, nothing had happened. February 5. February 5, there was that fourth complaint, which is believed not falling within Article 11, Section 2, Section 3, Paragraph 2, but Paragraph 4, which they said we had 1/3. Now, these are simply the facts. These are simply the facts. Now, how did this play out? How did the Supreme Court read this? Okay, you had the 3. There was no setting, inclusion in the order of business. Only based on their counting, the last day could have been February 5. And together with the 3 was the fourth one. And if you get to read the decision of the Supreme Court, they incorporated therein the journal, if you get to see it. The journal said that there was that fourth, and that there was the necessary vote, and the 3 were actually archived. This is where exactly the analysis of the Supreme Court came in. The Supreme Court explained that it's a mandatory provision, that the same should have been acted upon immediately.
Which means yung dalawang periods should have applied yung paglagay sa order of business and then after 3 days, refer to the Committee on Justice.
That was clear in the Constitution. So they said that the House of Representatives, specifically the Speaker of the House and the Secretary General, had no discretion. Had no discretion. So having said that, and leading you to the next statement, the Supreme Court said because it is archived, it is deemed dismissed.
Yeah.
Therefore, because of that appearing in the records, in the journal, kumagat, there's a bite of the first.
Meaning
there was
acted
already,
upon siya.
yes, there was already a dismissal.
So, Attorney Tranquil, before touching on the procedural, rather the due process aspect, because the Supreme Court decision partner touched on both procedural and due process. Before I go to the due process, just briefly, offhand, from what you just enumerated, ano lang yung sinabi mo? Very clear, klarong-klaro, no? Di ba ito ay yung ginawa ng ating Kongreso, ng House noon, ito'y sang-ayon sa mga desisyon dati ng Supreme Court, ng Davide case, ng Francisco case. Ito po ay sang-ayon sa kung anong nakalagay sa ating saligang batas.
Okay.
Is it? I mean, I'm saying, are the facts of those other cases similar to what we're facing right now?
That is where I will lead you on this matter, answering the question of Mike. No? Because the facts of the Francisco case was different from the facts of the Duterte case. The facts of the Francisco case happened this way. At that time, the one who initiated the impeachment of former Chief Justice Davide was former President Estrada.
Yes.
Endorsed by a number of congressmen.
I remember that.
You remember that. You remember that.
Yes.
And then, it was included in the order of business. It was referred to the Committee on Justice.
Within the mandatory period.
Yes, within the period.
In short, nag-comply dun sa
period under Article 11, Section 3, Paragraph 2. And then they dismissed it.
Yes.
The day after, they filed the second one.
I see.
So, in that, based on those factual antecedents, the Supreme Court had to explain the concept of, number one, who can initiate, and it's only the House of Representatives who could solely initiate, that was made clear, and how initiation would take place. It's not merely the filing, okay, but the filing coupled with the referral.
So in that case, the Francisco case, that was considered initiated.
Yes, it was considered initiated. Therefore, there was a bar on the second one. And for the longest time, that has been the standard, you get me, when it comes to impeachment. Now, moving forward, sometime in 2010, the case of Ombudsman Gutierrez.
Yes.
Okay, another impeachment case, the factual antecedents were a bit different. There was initially a complaint filed during the adjournment, meaning that period before they commenced with the next Congress.
Yes.
There was a first complaint. Then thereafter, a few days thereafter, after the resumption, then they filed another complaint. Together with those, it was scheduled together in the order of business and referred to the Committee on Justice.
Again, complying within the
Yes.
periods of
Yes.
Article 11, Section 3,
And
Paragraph
the
2.
Supreme Court said, in that case of Ombudsman Gutierrez, well, it was properly initiated. Okay? So even if there were a number of
Yes.
complaints, it was taken together,
Yes.
included, so there was no violation of the 1 year
And
mark.
eventually, anyway, she resigned.
Exactly.
So
Yeah.
therefore,
Exactly.
it did not progress.
Yes.
But
So
I
just-
remember just so
Yeah, go ahead,
because
partner.
it's still relevant to this
Yeah.
specific section 11,
Article
Article 11,
11,
Section
Section
3,
3.
Paragraph 2. Yung part of the decision also said that if they don't rule otherwise, meaning to consider or to deem the archiving or inaction as a dismissal, then technically Congress can also freeze or
Okay.
unduly delay.
Actually, with that, I think this is just an objective discussion. Let's try to do this. If without the Duterte case, they could actually determine what would go and what would not.
Yeah.
Okay, there is the 3, and if you strictly say, well, the Francisco says there should have been inclusion in the order of business
Yes.
and referral. We did not. And that's exactly what they're saying.
Exactly,
Now,
yeah.
the matter was actually explained by the court in its ruling. They say, do you have discretion to hold on to it? And the Supreme Court said, you have no discretion. The Speaker and the Secretary General had no discretion. And therefore, considering, and if you read the provision of the Constitution, it says shall.
Yes.
Shall. You got to read it. It says
Mandatory.
shall, mandatory. You have to act within the periods mandated. Besides, during that period of time that it is in the committee, they have 60 days to conduct the hearing.
Correct.
And later on, we will discuss that in light of the due process requirement.
So I remember what they said was
Yes.
applying the verba legis doctrine. Yung words of that
Yeah.
provision are very clear.
Yes.
So you have to act within those
Yes.
periods.
But before again we go to the due process,
Yes.
quickly again on this point,
Yes.
because wouldn't you think or wouldn't you say that with what the court has introduced in this decision, this 97-page decision promulgated July 25, the way they define initiation now, which is I think medyo iba sa ating saligang batas, at least yan ang pananaw ko, no? Kasi para nangyayari dito, kung yan ang definition mo ng initiation, what you can do to shield yourself from future impeachment cases is to have someone to file an innocuous,
Yes.
worthless
A worthless complaint.
complaint. Therefore, that worthless complaint, since hindi na dumaan sa proseso na sinasabi ng Constitution with what should be defined as actually initiated, kasi nga a mere filing in itself is already considered initiated, pag final yan, the 1-year ban applies.
But isn't it, it's
Ergo,
not
you can already shield yourself.
Yeah.
Allow
But it's
ba-
not the actual filing,
Yes.
from my understanding. It's the fact that you don't act within the mandatory
And allow me
periods.
to mention this. This is stated in the ruling of the court. It says that if you file a complaint that is not verified,
Yes.
the 1-year ban will not have a bite. Okay.
Okay.
Or if you
Will
file
not.
something, a complaint that was not properly endorsed, then
Okay.
it will not have a bite.
Okay.
I think, as you mentioned a while ago, yes, they could decide that probably I will file a complaint that may appear to have some sort of substance
Yes.
and form.
Yeah.
But the flip side of that is also what you mentioned. If this is not addressed by the court, what happens now would be, okay, come on, everything you could file, and that it is now our discretion. But again, allow me to further discuss this, because some people will say that is solely the power of the House. That is solely within the power given by the Constitution to the House. And that is, I think, the reason why the Supreme Court would have to make a ruling.
Now let's go into the due process, because
Yes.
that's the second partner, is the due process. In your view, does the new requirements of due process that the Supreme Court recently came up with prior to transmittal to the Senate, does this really align with the Constitution?
Okay, allow me to explain this. The last paragraph of Article 8, Section 3 says that the Congress can promulgate rules to carry into effect the impeachment rules under the Constitution. Okay? Now, both of them would have their own rules. Now, allow me to break down. There are 7 items, if I think you're aware of that. There were 7 items that were broken down by the Supreme Court, itemized. The Supreme Court said, if there is a complaint, it should be supported by evidence. The second one is that if there is a charge, the charge should be sufficient. Okay? And then the other party, which is the respondent, should be given a copy of the same. Now, allow me to explain this. This is already there in the rules. Why? Because when it gets to be referred in the committee, that committee determines form and substance. And at that point in time, the respondent will be given a copy of the same. And if you recall, the most recent one that we had on this level was in 2019. The former Chief Justice Renato, where the committee conducted an extensive hearing. You get me? So you will be given a copy, there will be a hearing, and based on the mandate of the Constitution, you have 60 days for them to conclude it, and thereafter, whatever the outcome is, whether to allow an impeachment or not, it will be elevated to the plenary, and they will have to vote on it.
Well, in this specific case facing the Supreme Court, did they rule upon the fact that Vice President Sara Duterte did not get a copy of the impeachment complaint? I seem to recall
Yes.
a portion of the decision.
Allow me to explain it. That's why this part that I'm explaining is Article 11, Section 3,
Paragraph 4.
2.
Paragraph 2. Okay.
Let me now lead you to the item 7 of the enumeration.
Okay.
And there is an A and B.
Yung mga
And I think
requirements.
there is where a lot of discussion is about. This is where. Because under Section 3, Paragraph 4, it says that the verified complaint or resolution, if signed by 1/3, right? If signed by 1/3, will be transmitted to the Senate and trial will proceed forthwith.
Forthwith.
As the
Yes.
articles of
Yes.
impeachment.
And that will be considered as the articles of impeachment,
correct.
right?
Yeah.
This is where the contention, I think, lies. And there are just two items. The two items there, if I may mention, one is that they said, please provide all of this respondent at least, please
copy.
provide them with a copy because those who will, it is the House of Representatives that will file, right? And not the 1/3 only. It is the House of Representatives. So allow them to read it, right? Allow them to read it. Now, so others will say, no, it's so burdensome. You know, I don't need to read it. Now, the fact of even providing them a copy may be too burdensome for some. Now, this is just a thought, no? At this age of digital and electronic, you could share it electronically, actually.
Correct.
You could
Yeah.
share it electronically. Now, what the decision says, there should be a modicum of deliberation. And if you redefine modicum, it's a little bit. So if it is if it's a resolution, if it probably just for me, if it is included in the order of business and there was some sort of deliberation and there is a quorum, probably. That is what they expect. But that was not mentioned. I don't want to be misquoted on that,
Yeah.
right? But there is also another item, which I think a lot of people are raising points. And what is that? The fact that though it's 1/3, you provide a copy to the respondent.
Yeah.
There is such
I
a
remember.
yes,
And
you provide a copy to the respondent, but the respondent can opt to waive having been served the copy.
You're talking about
Yes.
that in the Supreme Court decision,
yes,
right?
yes. I'm referring to that's item 7
Yeah.
of the enumeration.
These were 7 things that the
Yes.
Supreme Court instructed
Yes.
that why it is a violation of due process. And that's why, just on a, how do I put it, on a philosophical standpoint, for example, legal and philosophical, on due process, in your view, Paniero, isn't it, don't you think that accountability should occupy a higher plane? Due process, as we know, as we define it, is the right to be heard and the right to hearing. No? So essentially, that is due process. But in this case, the due process applies only when it comes already to the trial. When it comes to the hearing, rather the referral to the committee or the 1/3 members of Congress submitting the articles of impeachment to the Senate and trials should go forthwith, hindi pa na-attach yung due process. Ano ba yung na-deprive? In my view, ito ang tanong ko, ano ba ang na-deprive sa respondent dito na masasabi natin na may violation of due process? Di ba due process is the deprivation of life, liberty, or property? Na-deprive ba yung liberty? Na-deprive ba yung property without due process of law?
I think it was explained in the decision itself, and it cited a number of jurisprudence, including the leading case of Angtibay for purposes of administrative due process.
Angtibay versus
Yes,
CIR.
yes, lahat tayo na pag-aralan natin dyan, di ba?
Yeah.
Dapat may notice ka, paliwanag mo, bago kami magkaroon ng resolution. But I would want to be very clear, na-discuss natin yung Section 2. We are discussing Section 4.
Yes.
Now, the Section 4, to my mind, I don't want to discuss, to give my opinion at that point, because that is to be decided by the court. I think that is a matter that is presented in their motion for reconsideration.
Yeah.
Yes.
But I would want to touch on something which is in the provision of the Constitution. And what is that? You mentioned it. Verified complaint or resolution. And we, the three of us are lawyers, what is verification? In the rules of the House, doon na muna lang tayo. The rules of the House, what does verification require? Meron silang form doon. And that form was incorporated in the 97 decision. The 97 pages decision of the court.
Yes.
Kinopya yung provision, nilagay. Ano yung verification? The verification says, I have read the same, and that based on my knowledge, it is true. And that I have examined the documents, and for that reason, I will sign. So, tayo na nagpa-practice, sasabihin natin sa kliyente natin yan. Because under the provisions of the rules of court, ito naman just for purposes of further discussion, under Rule 7, Section 4, you don't need to verify something which the law or the rules does not require. If the law or the rules do not require it to be verified, hindi. But this is specifically a requirement of the Constitution. So allow me just to, I explained it, but the matter of yung sinasabi niyo, the service, because I think the matter of the service of the copy of the is something that they may have raised in the motion for reconsideration.
That specific
that
requirement as adding something that the Constitution does not require.
Yes. That's why I don't want to give a personal opinion on that at this point.
It's still sub judice.
Yes.
But at least with respect to verified complaint for the public's
talagang
knowledge,
verified.
nandun
Yes.
talaga
Nandun
siya sa
talaga,
Constitution.
Nakalagay sa Constitution, meron silang rules. Ang kaya nga ang tanong, I think the question would be, would you sign something that you haven't read? I think that's a basic question.
Yeah.
I go back to your question, which would prevail accountability? Definitely. And that is, I think, why the 1987 Constitution is breathing life. But again, in the effort to make that accountability work, the thing is, how do we do it? Does the Constitution require that it is verified? The Constitution requires it.
And just very briefly, to add to what you said, it's now even easier
Yes.
in the 1986 Constitution as compared to the 1935 Constitution, partner. In the 1935 Constitution, it was harder to impeach an impeachable officer. The requirements were what you call this? Rather, it was much harder because mas mataas yung threshold.
Yes.
I think the framers, and then the framers of the 1986 Constitution decided, no, let's make it easier.
Yes.
That because at the end of the day, public accountability is crucial for good governance. So the sovereign must be able to change leaders, especially those that were not elected, were just appointed, if they go violate the provisions of the law or the Constitution. Kaya they made it easier now.
Yes.
Kaya makikita mo talaga yung framers ng Constitution, gusto nila talaga na talagang pag merong kasalanan, wag natin pahirapan.
Yes.
Ang nangyayari, partner, and then perhaps you could comment on that, is also procedural and due process. This decision of the Supreme Court has actually made it more difficult to impeach an impeachable officer. Lalong mahirap ngayon mag-impeach. Nagdagdag sila ng mga requirements na hindi dati nandun sa saligang batas. Of course, at the end of the day, as lawyers, siyempre lumabas na yung desisyon, we have to follow in the meantime. But we know that it's possible that can change. Pero nagdagdag sila. And that will make it now more difficult. And that's why we can also argue na, paano ngayon yan? Kasi ang mga Supreme Court justices, they are also impeachable officers.
Okay.
One would think siguro na baka naman linagay nila to dahil para if the time comes.
Let me address it.
But I guess my question would be, do you think that those requirements made it more difficult? And second, does the Supreme Court have the authority to add more requirements?
Allow me to explain this.
Yeah.
Okay. First, we have Article 8 of the Constitution. Article 8 of the Constitution, Section 1, which the Constitution provided the Supreme Court with the power to review actual controversies if there is grave abuse of discretion amounting to lack or excessive jurisdiction. We call this the expanded certiorari jurisdiction, different from Rule 65 of the Rules of Court. Now, if you would remember, historically, this was not present in our Constitution. It was only introduced in the 1987 Constitution because of our historical background, historical political background. They would want a little bit of a check that if there are some excesses on some branches of government, then the Supreme Court can come in and can interpret. But allow me to make a short or a small annotation. For the longest time, for the last probably since 1987, there have been so many journal articles about this. There's so many journal about what they call is a judicial reach. Now there is a statement of judicial overreach, right? But then the Supreme Court, I'm not saying that we have to accept because the Supreme Court has the power. But kindly take note, there is what you call also in our jurisprudence as equity jurisdiction. Equity jurisdiction. I've had cases like that. I've had cases like that where clearly the procedure or even the mandate or the wording of the law is clear. But the Supreme Court says, probably you're right. But justice and fairness requires this. I'm not saying that that is how it is. It has to be read. But what I'm saying is that there is what you call equity jurisdiction. Now, let me address your statement about the Supreme Court justices being probably insulating themselves. I think some of these people have been saying this. I think that was also how it was raised in the Francisco case. There was already some misgivings at that time. But I don't think with our political history, if there is really a move to impeach, regardless of what you put there, you will be impeached.
Parang
That's how I
yung
see it.
sinasabi
Yes.
ni Senator Tito Soto kahapon sa plenary sa Senate na kung gusto, may magagawa ng paraan. Kung ayaw, magagawa din ng paraan.
I think with us Filipinos, una tayo, ayaw natin yan eh. But when we get to see it, and then kaya natin yan, and they really want to impeach, even in the House, there's so many lawyers there. They could just put the charge, put it in order. I think, and this is with all, with all objectivity, I think probably the Supreme Court was looking at, anuhin nyo naman, di ba? Siguraduhin nyo, basahin nyo, lagyan nyo ng charges, okay lang yan eh. Ikarga nyo. If you have the support, that will fly.
So, in line with what my partner just said, no? Yung kung gusto mo mangyari, at sinabi mo rin, kung may impeach, di ba? So, am I to understand that in your view, as we have been arguing or talking about it, sui generis ang impeachment, it's both political and legal.
Yes.
But sa tingin mo kaya, mas political ba siya kaysa legal? Or could you say na yung sa House portion, yung pag-initiate ng impeachment proceedings on articles of impeachment, whether it be any of the modes allowed by the Constitution, that's the political. And then the legal could be the trial in the Senate. Would you agree to that? And may dagdag pa ako. Even if, let's say, legal yung trial sa Senado, you can consider it legal. But at the end of the day, when the way they decide, is it really legal? Because the way they decide, let me just say, when they decide, partner, when the senator judges pag tumayo at nagsalita and they vote acquit or guilty, they don't have to explain their vote.
Yes.
They do not have to explain their
Only
vote.
if they want.
Only if they want. So that for me is very political.
Yes. Now, this was explained in the case of Sereno, that it is both a legal and a political process, sui generis. Now, in an academic discussion, when we say legal, of course, that's procedure that we have to follow. Political is that someone will have to account, you holding public office. But let me be a little bit pragmatic and realistic. Okay, allow me, just for this instance. Because when we talk of political in that sense is probably how do you read situations? How do you look at real situations within the Philippine terrain and environment, political environment, and that somehow, are you to vote in this manner? And that is why I think, probably, just to my mind, it is time for us to just request, I think that's what the Supreme Court was trying to tell them, modicum lang naman of deliberation ng ano namin. Sige, tingnan nyo kung ano. Hindi, I think they understand that not all are lawyers. And that not all are expected to be able to know. And in fact, I recall that in one of the rules of the House, they even said that it could be in a resolution, it could be passed in the same manner as a bill. So there should be some formal process, I think, just to go through with it. Because I think naman, to my mind, that before that complaint, verified complaint, based on the 1/3 paragraph 4 is transmitted, there will be a proper resolution. And there will be an entry in the session of that day, and there will be entry in the journal. That is to my mind.
Yeah, but since we're on the topic of the impeachment being a political exercise, but also sui generis, I want to ask a question that is very political. So even during the Corona impeachment, diba?
Okay.
Remember there was a press conference of one of our co-members in the defense team that said that meron daw ino-offer sa mga senator judges para mag-vote to convict. May pera, oo. And then, but a year and a half, and then that person, that lawyer sa team namin, ay na contempt ng Senate Impeachment Court nung nag-trial ulit.
Yes.
And, but about a year and a half later, 2 senators had privileged speeches saying that they indeed were given money or some sort of funding in order to vote to convict. So, my question is, the same thing is being insinuated right now with this impeachment in a sense that merong sinasabi na may umikot daw na pera or inoffer sa mga congressmen to sign the articles of impeachment. So this goes kasi to that question whether did you read it, is it a verified complaint in accordance with the law, or is it political na, okay, may kapalit to, so pipirma ako. Will that affect the legality of the complaint? I mean, so theoretical
Karen,
na
I don't want to reach that point.
Yeah.
Because that could border on speculation.
Yeah.
Being a procedural law professor, I wouldn't say, unless I have specific knowledge of evidence, I will not say.
Yeah, so it's a hypothetical question. Meaning, I'm saying like, kung may totoong case that is proven that the members of Congress, instead of, the process of reading and making it into a proper verified complaint, if there was really money exchange and therefore it was fast-tracked, would that affect the validity of the impeachment complaint, or is that purely political?
I think for the longest time, all of the impeachment have been, I think the only one that was completed is that of CJ Corona.
And that is true.
That's the only impeachment that was completed. And he respected it. He respected it.
Yes.
You have to give it to the man.
Yes.
And I recall, and allow me to share this, considering that you mentioned this. I recall that on the day of the conviction, he was in the hospital. He was not there when they gave the guilty verdict. Each one of them gave their position. And then, I don't know if you remember, the rest of the team talked to me. Sabi nila, in vernacular, sabi niya, bakit pa ba tayo ng certiorari? Because there's an Article 8 section. Bakit pa ba tayo? Wag na. Diba sinasabi lang, wag na. Because a lot of us were actually handling actual cases. Pare, alam naman natin, wala na. So, sabi niya, you talk to him. So, I talked to him. Actually, I talked to him. Sabi ko, I want to. Sabi ko, CJ, I came to you to ask you, because the rest of our team members would want to know, are we moving forward? Or are we doing anything? Sabi niya, gusto sa madaling salita, magsisertiorari ka pa ba? Sabi niya, hindi na. Sabihin mo sa kanila, hindi na. Okay? Second, sabi niya sa akin, hindi ko makalimutan to, sabi niya, alam mo, okay, so lalabas na ako kayo sa Supreme Court. Sabi niya, alam mo, susulat na lang ako ng libro ko. Sabi niya, ng biography ko. Yun ang sabi niya sa akin. Sabi ko sa kanya, not yet, CJ. Your story is still being told. I remember that. Your story is still being told.
Yeah.
Sabi ko, so don't. But I think 2 days after, that was already out of the news. Because he decided to accept it.
Yeah. But I remember that a year and a half later, nung nagkaroong privileged speeches, one of the lawyers also in the defense team
I remember you mentioned
we can
that.
actually go to the Supreme Court to have a mistrial declared.
Actually,
so that's why, for me, it's a legal question.
Yes. Actually, I'm aware of some desire to question it. I'm aware of some desire. And I think, deep in his heart, actually deep in his heart, he doesn't want to come to return, but deep in his heart, he wanted to show, tama rin ako eh. He
So,
wanted.
before we discuss the
Yes.
legal implications of issues like that in this
Yes.
political exercise, we'll have to take a short break.
Okay.
Our conversation with Attorney Tranquil Salvador continues right after. This is Abogado.
Welcome back. You are watching Abogado. And before the break, Attorney Tranquil Salvador discussed the legal and procedural complexities surrounding the recent Supreme Court ruling and the institutional responses that followed. Perhaps, partner,
Yung
let-
hanging question ko lang,
Yeah, hanging
because I
question.
really just want to
Yeah.
settle that in my mind. Kung may mga ganun
actually,
types
she
of
also asked that from
allegations.
Attorney,
But
Justice
si
Tony
Justice Carpio kasi said, I don't want to engage in speculation. But for me,
Pareho kami
it
na
is
sagot.
real because the
We don't wanna
public,
speculate.
Yeah,
Yes.
but for me,
May
if
point si
it's
partner
it's a
eh. May
legal
legal.
question that if
Oh.
there are,
Yes.
let's say, really allegations like that, then will the Supreme Court try it? And then kung may findings na meron talaga,
I
sila ba
think-
yung proper forum
Okay,
also
I
that can
think-
declare a mistrial?
Allow me to explain
Yeah.
that to you procedurally.
Yeah.
If they believe that there is sufficient evidence and that there will be testimonies,
Yes.
there will be documentary and object evidence, file a case. Now, the question is, do you file the case with the Supreme Court? Because Article 8, Section 1 recognizes the court, not only the Supreme Court. Because that would require reception of evidence.
Yeah.
It may be appropriate to file it in the trial court.
What about sa impeachment court? Kung let's say ongoing pa impeachment, but the respondent is alleging that complaint was not properly verified because, let's say,
I think on the matter of verification, okay. But on the matter of what you say, probably
that
handing
money
money,
or-
I don't think
or-
that the impeachment court will even look at it. Because that what you mean by trial will proceed forthwith would be the accountability of the person charged.
okay.
Okay. If you want to file charges against those who may have acted because of some facilitation,
Yeah.
you file an action in court and prove it. And probably you could use that to invalidate a proceeding.
that could
But
invalidate
yes,
a proceeding.
you cannot just say, I will go in here, I would say, these are the people who received so-and-so. You have to prove it.
Yeah, and the proper form would be a court.
Yes, would be a court.
Now, Attorney Tranquil, let's go now to the motion for recon that
Yeah.
was recently filed by the Solicitor General on behalf of the
Yes.
House of Representatives. Sa inyong pananaw, kasi nakikita naman natin na malakas naman yung mga argumento at pati na rin yung, intervention na final ng isang bayan. No, it was led by Justice Tony Carpio and together with my good friend Howie Calleja. Yeah. Kasama ko sa Rotary.
Kaklab mo
Rotary
ba?
Makati. No, but eto, no, eto may intervention, malakas din yung grounds, may MR, malakas yung grounds, but really,
What are the
the chances?
Can you allow me to explain first the
Okay.
MR
Yeah.
Okay.
Yes.
and the
Please.
concept of intervention? So
Yes,
that our
yes.
televiewers who are
Yes.
not lawyers will have
Yes.
some sort of an information.
Okay.
You know, you file a motion for reconsideration. This is not an appeal because I've heard a lot of people that, you know, you appeal the
Yes,
decision.
yes.
This is not an appeal. A motion for reconsideration is filed, number one, if you believe the decision is contrary to law. Number two, you file a motion for reconsideration if you believe that the judgment is not consistent with the evidence presented. And the third one is the award of damages is excessive to that which was presented. But of course, there's no claim for damages on this point. So that's a motion for reconsideration. And as mentioned by Attorney Mike a while ago, there is what you call intervention. Intervention is under Rule 19 of the Rules of Court. And intervention is you would want to participate and to join in a pending litigation already. Either as a petitioner or a respondent, which I think probably, as they said, they would want to intervene probably as a respondent. Not for the VP Sara.
Yeah.
I don't think so. They would want to
For
intervene.
Congress.
Yes, but you could also intervene under the rules of court as a petitioner against the both of them. Because as they say, we are coming in for the sovereign people. For the ordinary people. Well, they could do that. But again, the court, before the court will entertain you, the court will have to determine whether you have locus standi.
Standing, yeah.
Whether
standing
you
to-
have legal
yeah.
standi. Ano ka ba? Kaya if you would recall, when Howie gets to be interviewed, he said, we are taxpayers.
Yeah.
Yes.
Because that is standing.
I remember
Yes.
the petition filed in the Supreme Court that led to this decision. Nag-intervene din, I think sila Attorney Torion as taxpayers.
Yes.
It was...
I think they joined as petitioners. I think they
joint petitioners pala.
That's
hindi
why the decision, dalawang kaso yun, no?
Yes,
Dalawang
they
kaso.
joined.
Yeah.
They filed separately.
So what is the likelihood for an MR since it is only granted in exceptional cases and you named the grounds?
Okay.
Yan yung mga tanong sa mga tao ngayon.
Okay.
Ano yung likelihood na ma-overturn pa yan on an MR?
Okay. I've seen cases wherein the Supreme Court reconsidered. You will see whether in the lower court, in the trial court.
Even if it's 3-0.
Yes. Well, ayokong magsabi na, wala na yan. Alam mo yun? Hindi. Because, again, as a professor, ayoko rin gawin sa mga estudyante ko na, pag ganyan, wala na yan. Huwag nyo naintindihan yan. No. Sometimes, it's hard. Sometimes it's uphill. I've seen uphill cases. And at the end of the day, you see the light. You see? So you fight it out, you explain it well, and pray that hopefully your pleas are heard.
The Holy Spirit bring wisdom.
Baka mag-intervene din yung voice.
That's what you do. Kaya mahirap ko kasabihin na, but let's say, very pragmatic practitioner. Alam mo yan, yung pragmatic practitioner. Sabi na, parang naman, 13-0 na yan. Alam mo yan? Sa tingin mo ba yan? Maano pa? Kahit pamabawasan yan eh. Di ba? Ganun yun. Biglang mag-dissent yung isa dyan. Di ba?
Yeah.
So, that's a very realistic, pragmatic lawyer. Alam mo naman, tayong umahawak ng kaso. Sa dami na rin nakita nating klase ng kaso, sometimes we become more realistic.
Yeah.
Di ba? Tanggapin mo. You take the blows as you move along.
Well, with respect to the MR, last week, retired Supreme Court Justice Carpio was talking about a vote on the plenary na sabi niya happened in Congress, but according to the Supreme Court decision, it was one of the things that was not taken into consideration. But the Supreme Court is not a trier of facts. Will this make a difference ba sa MR?
No, I would like to be very clear with this. While generally the Supreme Court is not a trier of fact, but the Supreme Court has the power to subject to certain exceptions. If there are inconsistencies in the facts, for example, the findings of the lower court is inconsistent with that of the Court of Appeals, when it would violate the rights of parties. Naku, ang dami niyan. Ang daming exception yan. The Supreme Court can do that. Now, if they're saying, I recall, correct me if I'm wrong, parang sinasabi nila yung session days, yung adjournment daw. But if I think they're making an issue out of, just to state the facts, it's not yet a sine die adjournment. It's not. That February 5. It was an adjournment because there will be a campaign.
Yes.
Right? And then they will return sometime in June 2, right?
Yes, which they did.
It's not yet. But again, I think the Supreme Court, and this is just based on my reading of the decision.
Yeah.
Because the Supreme Court quoted the portion of the journal.
Yes.
Wherein it says, yung panghuli dun, archive. Doon nila in-interpret yun. Based on the journal. That's how I see it. Nandun yun. Those of you watching, you could scan it, you could do an AI, and check what I say.
Kaya maganda yung sinabi, yung tanong mo, partner, no, when you mentioned yung facts, no? Because I think yun ang mga, for example, the position of former Chief Justice Renato Puno.
Yes.
It's very simple. Sinabi niya, ito ay kailangan talagang ultra careful tayo sa pag-understand kung ano talaga ang factual basis ng decision. Because at the end of the day, on the first point, especially on the procedural point, it will be based on the actual facts which one can determine sa journal. May sinasabi na one of the decision that was based on a media coverage which allegedly said that they were quoting ABS-CBN, which by the way denied it.
Allow me to
So paano ba yun?
Allow me to explain that. I think I read that portion of the decision, and I read also the portion of the petition, the petition, because it was uploaded,
Yes.
publicly available. And I think they were presenting it in light of, did the Secretary General act immediately? Because the rule says immediately.
Yes.
It didn't even say this number of days,
Yes.
10 session days.
Yes.
It says immediately the rule. So what they did was to enumerate those interviews like this. Kaya mahirap pinagsasalitang ganito eh. They will hold you on this.
Kung malagay ka sa Supreme Court
Gusto ko
decision.
pa naman sana tanungin your fearless forecast.
yes.
Oh my God,
No,
my
no,
MR.
I never
Now
do
I
that.
know that hindi
Remember partner,
Yes,
yung tinanong mo si former Justice Ascuna, natawag tuloy siya sa isang Senate hearing.
Oo nga eh.
Hindi ako magagawa. So, yun yung andun yung facts. Ito yung sa network, this network, in-interview ka, sinabi mo.
So since we have only 5 minutes left,
Yes.
I just want to end on this note because nag-decide
Yes.
na ang Senate to archive
Yes.
the impeachment.
Yes, yes.
Ano nga ba difference na archive and mag-table lang?
If you would recall, and if you were able to monitor it, that was 7 hours.
Yes!
That was 7 hours.
Oo nga eh.
So,
Actually, tinatapos ko siya. Basta up to now.
you know,
Kasi hindi-
that was 7
natapos
hours.
ko
It
gabi.
started at
Oo.
3. So, after my meetings, I had to listen to it during traffic because I know, I already had scheduled interviews.
Yeah.
Diba hirap yung nagsispeculate ka eh. Ganito yung yung in Robert's Parliamentary Rules of Order,
Yes.
yung table kasi yan, it's equivalent to a postponement.
Yes.
Itabi nyo muna yan.
And you can take it up
Yes,
anytime.
take it up
Okay.
anytime. That's the intention.
Okay.
Kaya yung sinasuggest ng minority floor leader, hindi natin pwede itabing ganyan. Let's put it as some sort, let's table it so that it's just like postponed.
Yes.
Let's just set it aside for now. When it's, let's say the Supreme Court decides, pick up natin kagad. Ganun yun. Yun that's tabling. They wanted an archive. And if you've heard the discussion, the original move was to dismiss it.
Yes.
But eventually, it was amended to archive.
Parang compromise.
Yes, upon the suggestion of former Senate President Subiri. Suggest, sabi niya, mag-ano tayo. But if you get to hear the exchange of discussion, they arrived at a decision to do something because they said, in layman's language, mahirap yung nakalutang. Kasi yung mga tao, naghihintay ng ano ba? Kasi otherwise, sabi nila, pag hindi tayo gumalaw dito, abay, walang tigil yan. Araw-araw, yan na yung gagawin nila. So that, I think, that's not my view. That was what I heard during the exchange.
Ano yung
So in
archive?
a sense, yung archive
Yung archive is to actually shelve it eh.
Parang postpone din yun, di ba?
Yes,
Parang gano'n yung
in a
isip
strict
ko,
sense.
oo.
But allow me to explain it in the rules of court setting. Okay? Rules
Yeah.
of court setting. That is not found in the rules of court, the word archive. But you will find the word archive in the 2017 guidelines of continuous trial in criminal cases. Wherein, if you have a criminal case, a warrant of arrest has been issued. For 6 months, the person, the accused, has
Yes.
not been arrested.
Yes.
That case will be archived.
Archived.
Naka-shelf lang yun. So anytime, pero yung warrant nun, standing warrant yun. At any given point in time, 10 years later, 5 years later, hanggat hindi dismiss yun, arrestuin kita.
Pero yun nga ang nagiging issue, di ba? Parang sinasabi nila, at ito lang ang pananaw ko rin, no? Pag table, I think I agree with Senator Soto, partner, na to table and you define table.
Which is
following the
postponement.
rules of Parliament.
yes.
It can be postponed but taken anytime. Ang problema daw sa archive, kasi pag in-archive mo, bago mo buhayin, idadaan mo pa sa boto.
Okay.
There
Boto ka
must
na
be a
naman.
vote. Tama ba yun? Yun ang
Okay.
sinasabi nila. Pero sinabi naman daw nung mga majority, no, hindi na tayo magboboto. Basta archive lang, pero anytime we pick it up. But then again, we don't know.
Yes, I see your point. I see your point. Although I really tried to look into the rules of the Senate. I may have overlooked it, but I don't see a specific definition.
Yes.
But at the end of the day, I think the public can just be assured of all of their statements. They decided because they respected the decision of the Supreme Court, knowing that it is executory, and knowing that there is a motion for reconsideration. And that if forever the outcome is, itabi na natin yung mga annotation ng iba na wala
Yes,
na yan,
yes.
that if for one reason the Supreme Court acts in a different manner, then because they cling to it eh. Hindi nila pwedeng takbuhan yon, di ba?
Yeah.
Pinapitan nila yon eh.
Yeah.
And the public will hold them on that.
Yeah. And let's say they proceeded to try, despite that decision, ano yung magiging value ng decision ng impeachment court with that type of Supreme Court decision out there?
Alam mo, of course, as a lawyer and as a teacher, ako gagalangin ko yon. Kasi hindi ko gusto, ako lang, yung message na binigay ko sa estudyante, na kapag hindi nyo gusto, huwag nyo sundin. Ako bilang guro, ganun ko gagawin yon. Ngayon, siyempre, may iba sabihin, well, as students, you have to have critical mind. Diba? You should have critical mind. But hang on. Sa akin lang kasi may mga estudyante, when you talk of criminal, it is not equivalent to bias. It doesn't mean that you're biased and prejudiced, you're critical.
So
Critical mind is
legally-
trying to understand both
Yeah.
sides.
So legally, if there's a Supreme Court decision that said that the articles of impeachment were void ab initio and the Senate impeachment court never acquired jurisdiction, and yet the Senate impeachment court proceeded to try and decide, what is the the effect of that decision? Is
there's
it
a decision. Let's not set it aside in terms of impeachment judgment or decision. A regular decision, a judgment, an order of the court. You refuse to follow, you could may be held liable for indirect contempt. And if you are a lawyer, you could be exposed to the Code of Professional Responsibility and Accountability. Now, allow me to say this because, of course, the three of us had our oath. That will follow.
yeah.
Not only the law, not only the rules, but also the decisions of the court.
Because we're officers of the
We
court
are
as
officers of the
lawyers.
court.
Yeah.
Yun yung bigat eh. Hindi ko siya pwedeng sabihin na ganoon.
Okay. Sayang bitin pa pala, no?
Oo nga, no?
Kulang pa pala ang almost 1 hour to discuss this.
This topic is really very interesting, and ito talagang topic na to, partner, talagang I think for the longest time it will occupy the nation's consciousness. Kaya lalong importante na nandito tayo para maturuan natin ating mga kababayan kung ano ang nangyayari.
And I like that statement, Mike, if I may say this. Because what we're doing now is not for ourselves.
Yes.
Not those who are in this generation. Those who are students, those young people who are watching us.
Yeah.
Are we strengthening institutions?
Yes.
What do we do? What will we leave behind?
Yes.
Yeah.
That's how I see it.
And very applicable siya sa future if this happens again. So
In a few
I
years,
think
we're
that's
gone.
Yes.
Yeah,
Yes.
exactly. So that's a very good message to end this program on. So, Attorney Tranquil Salvador, thank you for sharing your expertise and helping us navigate the constitutional and procedural tensions raised by recent events.
Yes, that's the right term, partner. Tensions. Yeah, it's all over. It's very thick. But, tonight's episode reminds us that the rule of law isn't just about outcomes. It's about process, balance, and respect for co-equal institutions.
And as the legal landscape evolves, so must our understanding of the Constitution's role in guiding institutional behavior.
This is Abogado.
Good night.